Hey there, welcome to the bench. Unscripted, off the cuff, but fairly in-depth. We've got two reporters here, Rowan, Joel, and then an expert, a defense attorney, Leticia Quinones. Thanks for being with us.
Thank you.
You've been involved in some big cases yourself. We were all in the courtroom this morning as things got going. So let's do a quick check of what we think, how that went. I thought it was pretty interesting. And AJ Armstrong was sitting right there in the second pew with his family. What did you guys think, just real quickly, what do you think his sort of facial motions or his body motions showed you? Anything? Could you read any of that?
He looked to me like he was used to it.
Yeah.
You know, something that he had grown accustomed to. He's been in and out of the courtroom now for 6 years. This is his third trial. You could tell that he had been there before.
He really has been there.
And he did look tired at a point because we were there for like an hour where nothing was happening at that point. So I saw him hunched over quite a bit, speaking with his grandparents who were directly in front of him multiple times, just kind of waiting for things to get started.
Sure.
That's the feeling I got. He was just kind of maybe some nervous energy in there, but kind of quiet and reserved. And then things kicked off, and we started. It was supposed to get started, I guess, around 9:30.
Yeah.
Judge got it started a little after 10, and then right off the bat, we're looking at those motions that came slamming us last week, starting on Thursday. Can you run us through what that was exactly and how that all played out?
Sure, Joel. So I think she first started out by mentioning to both parties, hey, remember, I denied the defense motion for continuance last week. She then immediately went to the state's motion for continuance. I'm sorry, not that she did that last. What she went to was that the state had asked that all filings by either side be sealed, and that they are only made public after the judge has had an opportunity to review them in camera. And in camera just simply means where the judge takes evidence or motions and looks at them herself before it's made public to anyone else. And so the state was saying, hey, we would like for you to look at all motions in camera before you make it public. Well, much to my surprise, she denied that motion. And it seems like she was pretty clear that that is what she was going to do. So what Judge Kelly Johnson said was, I'm going to give the public what they have a right to, and that is access to any public trial.
The impetus for all of this, of course, started last week with the revelation or pseudo-revelation from the defense team that, hey, a member of the DA's office may have had some sort of relationship with a juror. Turns out it was an alternate juror.
Right.
The relationship was kind of maybe had ended, or it was unclear exactly where it was. But she sort of put that down quickly, right?
She did. And that's one of the reasons she said no to the motion for continuance. She just wasn't buying into any of those red herrings.
Really
right?
seemed that way, yeah.
And so then finally she went to the state's motion for continuance and says, I'm denying that too.
They wanted to delay. Why, though? Why did they want to delay?
They wanted it to delay it because think about it. The last thing that this potential jury pool heard was that the DA's office or someone from the DA's office was having an inappropriate relationship with the juror.
Right.
You know, and didn't disclose it. So of course that leaves in the minds of any layperson, hey, that doesn't seem right.
Right.
So do we really want to start trial after hearing that? Like the very next day we're picking a jury? No, you don't. You want things to kind of die down. And so that was the purpose of the state filing their motion for continuance. But again, the judge says, I'm not having it. We're picking this jury today.
Yeah, it looks like she was full steam ahead. Is that the feeling you got, Ron?
Oh, absolutely. She wants to get things started right away. We're going to look at 75 jurors, potential jurors.
We saw them all lined up. I mean, that was at the 18th or 19th floor?
19th
floor is packed. It was packed when the jurors were in there. 75 people just lining the sides of the hallway.
And typically we would be allowed inside for portions of that because there are so many jurors. We were all asked to leave, and I spoke with AJ Armstrong's grandparents. They were kind of disappointed. They thought they would be able to stay in there, but initially they, along with ourselves, were told to get out of the courtroom. Then they were allowed back in, which is what they wanted to do all along, just sit there with him.
I mean, just trying to physically fit 75 people as they go through this, this process. They're using like the jury boxes, I understand.
They are. They have to, because the gallery is what we like to call it, will only seat 64. 65.
Is that the typical panel?
Yes, the typical panel, 64, 65 citizens.
So what, they're just throwing an extra 10 in there? Why do they do that? Just a bigger pool?
Bigger pool because...
Bigger panel?
Yeah, just a bigger pool of people because of all the media attention that this case has received. And so in order to find a juror who's heard about this case, and is able to set aside anything that they've heard and be fair and impartial without considering that, it's going to be a little more difficult than your average case.
You know what I thought was the most interesting thing that happened this morning? Did you guys see that little back and forth between the defense attorney, Rick DeToto, and the prosecution about where one of their members was going to sit? Can you walk us through that? How did you guys read that?
Well, I thought it was interesting, right? It was certainly a tit for tat type thing. It was, to me, it was the defense attorney saying, hey, these are my grounds, and I am going to maintain and control it at all times, which is what you're supposed to do at a trial as a trial lawyer.
So the issue was an assistant district attorney was kind of sitting beside on their side, sort of in a, I don't know, is that a place where people usually don't sit, where she was seated?
No, they normally don't sit there because normally there's enough room at counsel's table, but because there's so many individuals that are going to be in the jury pool. Remember, we stated they're going to be sitting in the jury box. So if she was sitting at counsel's table for the prosecution, her back would be to them.
But where did she end up sitting? She's sitting the right way and somebody else moved or something like that.
She did move. So kind of drawing it out to let the audience kind of see a little bit, this is how it was. And this is where the assistant district attorney individual, she was sitting right there, right behind the defense team, and it was the defense attorney said, "Wait, she's too close."
Yeah,
so certainly what you're saying, they're bubble.
AJ is sitting right here.
Yeah.
And because AJ is sitting here, what Rick was saying was that if I come and say anything to my client, she's going to be able to hear me, and I don't want that added pressure.
And she was arguing, if I go over here, the jury box is here, then my back is to the jury.
And then if you remember, what Rick said was, I'm sorry, if we start balancing out who should, get the benefit of the doubt here, it should be the defendant.
Yeah.
And he should have the right to be able to speak with his counsel without the state hearing.
He won the argument.
He won the argument. Judge made her move.
Okay, so where are we now in terms of what are they doing up there as far as we can tell? What's going on right now?
Well, I want to say before we even get there was another motion that happened directly with language.
Right. That's right.
That particular language. Kind of talk to us about what that was all about.
Good point.
So the state ended up filing a motion in limine, okay? And what a motion in limine is that there's evidence out there. And before you can go into that evidence, so if the state is filing it, what it is saying is, hey, defense, before you can go into this particular evidence, you need to approach the bench. And you need to get permission. So we need to know, one, it's admissible and it's relevant at the time that you are bringing it up. Now, in this specific case, one of the things that they were saying is you cannot talk about whether this jury can give this young man a life sentence. And the reason being is because this is a non-death capital case. So in the state of Texas, there are only two punishments for capital cases: the death penalty or life without parole. Well, we know that death penalty is off the table because at the time that he was arrested, he was only 16.
Right.
You cannot kill a 16-year-old. And so the only other punishment that's available is life without parole.
So then what's the big deal, though? I didn't understand the argument. Why can't they say it? Because that's the only choice anyway.
Well, because here's the thing. Texas is a bifurcated state, which means we are one of the very few states that allows juries to assess punishment. And maybe 85% or more of the states in our union, the judge assesses punishments. Where we're rare, the jury can assess punishments. And when you are in voir dire, you have to qualify that jury for punishment. For example, in a regular murder, you get 5 to life. So you have to ask that jury, the state will say, or the defense will say, can you give someone who's convicted of murder 5 years? That's something we would want to know. You have to qualify that jury because a lot of people will say, no, if I find someone guilty of murder, there's no way I would give them 5 years. It would be more, right?
So what does that do to that questionnaire when we're going to go over that process, which is different from the get-go?
It alleviates any questions about punishment, which goes back to the state's motion saying, defense, you cannot say, can you give this young man life without parole?
Got it.
Because it's automatic. And so they just wanted to gatekeep that evidence in the way that the defense is able to talk about it. Because as you can imagine, if the defense gets up there and say, can you give this young man life without parole, that's going to offend a lot of people.
I understand. Okay, that does make sense. So if you're ready, we could talk about the process just a little bit.
Sure.
In terms of, so these 75 people from all walks of life, and it really looked like it when you were traveling down the hallway up there, they've already filled out an initial questionnaire, correct?
Yes.
And then there was some shuffling that happened. Well, can you explain what happened right in the morning? There was something we want to shuffle. What does that mean?
So anytime that a jury is in panel, they're actually across the street from the criminal courthouse. There is a jury assembly room, okay? And in that jury assembly room, those jurors are already assigned numbers before they cross the street and go over to the criminal courthouse.
Got it.
Before they make it over to the courtroom, the defense and the state already has their names, what number they're going to be seated in, and where they are, okay? And a lot of times the demographics that you may be looking for, remember we talked about getting grandparents.
Yeah.
Well, we know grandparents tend to be older people. Okay, so if that's a potential juror that I'm looking for, when I get that list and I see all the grandparents are way in the back, I'm going to shuffle them so I can get them closer in the lower numbers, because the closer you are, 1 through 40 or 1 through 32, the more probability that you'll end up on the jury.
Each side gets one shuffle?
Each side gets one shuffle.
And so the defense has just used theirs?
They did.
And that looks like that's going to be that on the shuffling?
That's that.
Okay.
That's that.
Got it. And so what, up there right now, what is happening?
So right now, I anticipate that they're doing a general voir dire. I do not believe that they've started individual voir dire as of yet. So now they're just doing a general voir dire.
And they will whittle people out that way, won't they?
Oh, sure. Absolutely. Absolutely. Because the judge is going to stand up and just do some general legal basics, such as the Fifth Amendment right to remain silent. Some jurors feel like if you're charged with a crime as serious as this, you should get up and say something. And if you don't say something, then I'm going to hold that against you and look at you like you may be guilty. Well, the Fifth Amendment to our Constitution says you cannot consider that at all when deliberating. And so the judge can voir dire on that, which we know voir dire means to tell the truth. And if someone says, yeah, if he doesn't testify, I'm going to hold it against him, that person is gone right there for cause.
Have we gotten any indication yet? Have you guys, how big how many alternates we're going to have here?
No, she really hasn't stated yet, but I'm thinking 4.
4?
At least 4.
Which is more than the going rate, isn't it?
Oh, yeah. Normally we'll have 1, maybe 2. 4 is a lot.
And you carry 4 just so you're all buttoned up in terms of having the bodies you need?
Absolutely.
And this could last, what, from this point, we could be 2 months away from the end of it at this point.
That's right. That's right. And as you know, anything can happen in 2 months, anything. And so you want to have enough jurors to replace someone so that you don't have to start this process all over again.
Yeah. And we got a brief of a schedule. They're doing the questionnaire now. Next, they'll have lunch. And then we're going to go into what we assume is the one-on-one questioning. And hopefully by that point, we'll see if we're allowed inside of that point.
You know, I don't know that they're going to start that. I think what they stated was they would fill out the questionnaire, and that questionnaire is the one that was agreed to by the defense and the state, which is separate than the one every juror gets who serves on a Harris County jury. This one is tailor-made to this particular case. So they're going to do that first, then have lunch, and then after that, the judge will speak to them, the prosecution, and then the defense.
The bottom line here is that the 178th, is that the court?
It is.
That Judge Kelly Johnson has said that this process is going to take a month.
Yes.
Are they just allotting, like, oh, it'd probably take a week, but we're going to take a month, or it's actually going to take a month to get through this portion?
I don't know that it would actually take a month. I think that she's allotted that amount of time just as a cushion. But it could. It very well can, because all other things can arise during this time. And so it could take a month. It's going to be close to it, if not.
Pretty action-packed for the first day, I would say.
Definitely.
All right. That's the bench. We're giving you the bench on the AJ Armstrong trial, and we're going to be joining you actually throughout the day on TV and also KPRC 2 Plus from downtown at the courthouse. For the 3 of us, we'll check in with you later.